All rise. The Court of Appeals Division 1 is now in session.
Morning. Please be seated. This is the time set for oral argument in OTTO versus OTTO, our civil number 18-0080. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal. It's up to you to keep track of your time in that regard. We have read the briefs, we've been through the record, we've conferenced the case, so we're familiar with the underlying facts and issues. We are recording these proceedings both by audio and video, and so I ask that as you approach the podium to begin your arguments, please identify yourself and your client for that purpose. With that, appellant may proceed.
May it please the court, I'm Jeffrey Kirschmar of Kirschmar and Feltis. I represent appellates petitioners here today. I'm here with Eric Hull of my firm, my colleague, and with the appellants Mark Otto and his wife Tammy Otto and their irrevocable trust, the AOM Trust. This is a civil appeal from a 4-day bench trial before Judge Gass in the Arizona Superior Court. As a result, there's a number of exhibits and facts cited by the parties in their papers that are going to be cited and discussed today as well. And the legal issues and case law cited by the parties were less prominent than those facts. But I'd point out that the vast majority of those facts are undisputed. They arise from documents and emails that are in the record. The court has and can review them. And the issues here largely boil down to how those facts are applied to the contract at issue, rather than what the case law says about contracts and contract interpretation, as important as that is. At the outset, I'd like to stress that appellees have already conceded this case was never about whether Allen owed Mark indemnification for his excess taxes in some circumstances. They agree that Allen must identify Mark if Allen has breached any term of the purchase agreement and has damaged Mark thereby. From page 18 of their answering brief, I quote, "Allen is not arguing that sections 5.02, 5.03, 2.05, or 4.02c were nullified, only that Mark failed to prove any breach of any of those sections in the agreement." And to avoid any doubt, appellees also say on page 24 of their answering brief, quote, "As Allen acknowledged, section 6.02 required that Allen indemnify Mark for any breach of a term or covenant in the agreement." End quote. Further, nowhere in the answering brief do appellees assert any ambiguities in any of these sections of the purchase agreement. In other words, appellees do not urge a different reading than the plain language meaning of these sections of the agreement. Those provisions simply mean what they say. I'm reminded that simply because there is litigation over these sections, that alone does not show ambiguity. We cited the Estate of Lamparella case, a 2005 case from this court, which indicates just that. And there, the panel found that the language in a divorce decree was not reasonably susceptible to the reading suggested by the ex-wife in that case. None of the extrinsic evidence below can be used or should be used to interpret these sections of the purchase agreement for that reason. Rather, all of that extrinsic evidence, other than being useful as background to the dispute here, is only to be used to determine if there has been a breach, not whether the purchase agreement means what it says or what types of conduct those sections prohibit. So to determine in the abstract what would be a breach, one need only read the sections themselves. The fact finder was to apply the evidence to those plain specific terms to determine whether a breach occurred, not to reinterpret their meetings based on what the parties had been negotiating about in the prior months. So, what we're here to discuss is whether the evidence in the record shows a breach of any of those provisions. I'd note that there's no factual findings below. Here's what the trial court ruled in its verdict. Quote,
Counsel, since you referenced that, did any party request findings of fact or conclusions of law?
no.
And how does that affect our ability to review the trial court's decisions?
This is a de novo review because in the section where the trial court ruled plaintiffs, counter defendants have not breached the equity interest purchase agreement, that is a mixed question of law and fact. This court reviews those de novo. There is no finding of fact, say, that one witness was more credible than another. There is no finding of fact that Romanet 4, the remove section that both parties talked a lot about, there is no finding of fact that that impacted the court's reading or beliefs about these provisions. The case cited by appellees, the Castro case, that was an interpleader action. The finding of fact the court was concerned about there was whether there had been a forged signature, not the ultimate issue of whether interpleader was appropriate or not.
But in this setting, a trials at court with no findings of fact or conclusions of law being requested, don't we presume that the trial court has made all findings necessary to support its findings, its rulings?
I think it remains a mixed question of law and fact, Judge Winthrop. The court, the panel, can certainly uphold this trial court's ruling on any basis that it finds. That is part of the standard review. If there is a basis to uphold the ruling, this panel can uphold it. But I don't think that as to individual findings of fact, that in the absence of those findings of fact, the court simply hasn't made those rulings. It remains a mixed question of fact and law as we apply to these contractual terms. The court, not cited by the parties, of course, but the SAL leasing case from this court in 2000, that's 198 Arizona 434. This court may draw its own legal conclusions from any undisputed facts. And that's what we have here, largely undisputed facts. I don't disagree that if there's a dispute as to facts, whether that fact is true, there is a fact which may suggest it's not true, that this court can draw the conclusion that the trial court below found the fact favored the appellees. That's correct.
My memory is probably not as good as yours on this, and I may be oversimplifying things, but my impression from the record was that there was a lot of disagreement about what the communications were and what they meant by each side. And so I'm not so sure that we can simply say that all these facts were undisputed.
Judge Winthrop, I don't think there's any dispute about what the communications were. They're largely emails, and we largely see them. One absent fact that wasn't in evidence, and that's probably more important, is what facts are not in evidence, is testimony from the appellee, Allen, about his belief that he owed no indemnity. They've conceded that fact. Also, as to what Romanet 4 meant. We're not going to see evidence like that. There is not a conflict about what those emails said. There is obviously conflict here about whether those impacted the interpretation of the contract. But again, I would remind the panel that neither side found these contract provisions to be ambiguous. Accordingly, they should be afforded their plain meaning. Yes, the parties went back and forth in negotiations. It's undisputed what those emails say. But to the extent the parties want to use those emails to color what's actually in the plain meaning of the agreement, that's impermissible use of extrinsic evidence to interpret an unambiguous provision in a written agreement. In Let me address the specific uncontroverted evidence then for each section that we contend was breached. Section 4.02C requires that the purchase price allocation schedule, this thing we call Schedule F, under Romanet 2, accurately sets forth the adjusted tax basis of the interests of the Mark OTTO parties as of June 30, 2012, and Romanet 3 is true and complete in all material respects. Now, the words of this section are not subject to more than one interpretation. There's nothing ambiguous about that. Now, there's a date in there, as appellees have pointed out, June 30, 2012. That date applies to Romanet 2, the adjusted tax basis only. Those historical basis figures were warranted to be accurate. Were they accurate? No. Exhibit 99 is uncontroverted, and in that email, Mr. Raftery, the longtime accountant for the companies and for Alan, frankly for Mark, he provided the basis figures as shown in Exhibit 68, and he admitted this in Exhibit 99, an email from about a year later. I have gone through the 4A basis schedules in detail, and you are correct. There was an error in 2006, 2007, and 2008 carry-forward numbers when the basis kept going in and out of negative basis. We will correct this and review the other entities as well and have updated schedules to you by Thursday. You'll find this exchange again in Exhibits 99 and 100. So here we have the auto company's accountant a year after the transaction closed saying the tax basis schedules are wrong. And they're not wrong after June 30, 2012. They were wrong in 2006, they were wrong in 2007, and they were wrong in 2008, and those errors continued. He was going to update the errors, and we have the transcript citation for you in our papers. He admitted on the stand that those errors impacted Mark's taxes. And on page 39 of their brief, appellees concede this. So only the basis figures were subject to that date of June 30, 2012, and as it turns out, it is undisputed that they were wrong. That's a breach. The rest of Schedule F wasn't subject to that date limitation in Romanet 2. Rather, Romanet 3 simply requires a purchase price allocation schedule to be, quote, true and complete in all material respects, end quote. Was it? Again, the uncontroverted evidence shows it was not. Allen admitted it was not in his testimony at trial. That's in the transcript of 7/24 afternoon. Mr. Raftery admitted it was not. He purposely left inputs that were uncertain in Schedule F because he thought precision in the allocation of the management fees was no longer critical to the deal. That's Exhibit 63. The net operating losses in particular were wrong. You'll find that in Exhibit 80. Appellees concede this. The net operating loss figures inputs in that schedule came from Mr. Raftery, and in Exhibit 41, he confirmed their accuracy pre-transaction. Schedule F actually has a footnote, number 7, which states the net operating loss and capital loss carryovers from 2010 of $1,042,011 is based on historical and prospective tax filings. Mark, the Mark OTTO parties, is relying on these estimates for the calculations. Our expert opined that those figures were not correct in her testimony at trial. And finally, she opined that the basis figures, the allocations, the income figures, and the carry-forward figures all differed from those in Schedule F, all of them. Appellee's defense is not that Schedule F was actually true and complete in all material respects. That's not what they're here to say, or at least that's not what I understood from their papers. They concede the breach. They simply argue that Mark knew about this ahead of the time. That's not a defense to breach, though. In fact, Mr. Raftery issued a number of warnings that he wasn't sure about the precisions of the figures in Schedule F.
Just to clarify one point, you just said that they concede the breach, and that's where you reference back to their answering brief at 18 and 24. You take that
No, Judge
You lost
Cruz.
me there.
They concede that the figures were not accurate.
Okay.
They contend that they're not accurate, that despite the fact that they're not true and accurate in all material respects, that because Mark knew about it or knew from Jim Raftery that he was having difficulty coming up with true and correct numbers, the warranty should no longer be binding. 4.02C, despite its plain, unambiguous warranty, it shouldn't be binding on them. Why? Because he knew about it. But Mr. Raftery's warnings, when he said, you know, he's having a tough time generating these numbers, they weren't directed to Mark. They were directed to Alan. He was telling Alan not to assume the risk of these numbers, but Alan did. He did in 4.02C. It made it into the agreement. It's a warranty. It's contained in Article 4 of the purchase agreement, which is titled Representations, Warranties, and Covenants under 4.02, which is Allen Auto Parties Representations and Warranties. The fact that Allen was clearly warned by Mr. Raftery does not somehow nullify the warranty that Allen gave Mark in this heavily negotiated agreement. Even appellee agree that it is not nullified, nor can its clear language be made unenforceable by extrinsic evidence. It's been breached. It caused Mark's damages, and the trial court's ruling to the contrary is reversible error. Section 2.05 falls under the consideration portion of the purchase agreement. It required the parties to allocate the purchase price in accordance with Schedule F, attached here too. And it required both the Mark Auto parties and the Allen Auto parties to file all tax returns consistently with the purchase price allocation schedule. Was that breached? Well, Allen admitted the companies did not follow Schedule F on the stand when they filed their tax returns. Mr. Raftery, the company's accountant, said it was impossible to follow Schedule F in filing the company's taxes. He said that on the stand in the transcript on 7/26 afternoon. And frankly, that's because it was so rife with historical errors on the inputs. A year after the transaction, October 7, 2013, Mr. Raftery emailed Mr. Hodges and Mr. Adamson, and he said this: following is a comprehensive list of issues we have become aware of just prior to the filing deadlines over the years that have never been corrected. That's Exhibit 154. His email lists approximately 60 problems in the auto company's historical tax filings, which he had prepared and he had submitted to the IRS, containing errors that were never disclosed to Mark or his negotiating team until a year after the deal was inked. In an email on October 8th, the next day, Mr. Raftery blamed the auto company's software for the problem and concluded, quote, these corrections could have a significant impact on taxes. So in correcting those errors, filing dozens of tax returns after the transaction closed for the years prior to the transaction, going back and amending those taxes over and over, the auto companies necessarily changed the way they had historically filed their taxes, requiring dozens of amended tax returns. That's in the record, transcript, 7:27 p.m., page 18, 9 to 15. Our expert opined, Ms. Monty, that there was no evidence that the auto companies, which were under Allen's controls after the transaction, filed their taxes consistently with Schedule F. Again, Appellee's only defense is that the errors that were intimately part of Schedule F somehow relieve them of the obligation to follow an unambiguous provision of the contract in Section 2.05. But that's not a defense, that's an admission. As stated in the briefs, of course appellees can file their taxes in accordance with the law. But if the problem was Schedule F, then they breached Section 4.02C and then Section 2.05. Moreover, if Schedule F were only an estimate, and if estimate somehow equates to non-binding, and let me point out, there's absolutely no evidence in the record that the term estimate that's found on Schedule F means non-binding. Even Allen didn't testify that it was his impression upon reading it that it was non-binding because it says estimate. Nowhere in the record is that testimony Nowhere in the record is any evidence of an email from the other side or Mark or anyone saying, geez, this is only an estimate. I guess that means we can't rely on it. I guess that means it's not binding. It seems like 4.02c is therefore nullified. No evidence is in the record taking that position. That is lawyer's argument only. And it was lawyer's argument that came about only after this litigation was filed. That position was never taken, not in the negotiations, not in the aftermath of the deal as the deal was being executed, and not even as we led up to this dispute, only after litigation was filed. So there's simply lawyer's argument that is absent from the record that estimate somehow triggered the belief in any party that it was non-binding. I only have half a minute, but I might as well reserve it in case some questions arise.
All right. Thank you, counsel.
Good morning, Your Honors. May it please the Court, Andy Gordon and Marvin Ruth from Coppersmith Brockman on behalf of the, excuse me, the Allen Otto parties, and with us today in court is Allen Otto. As Judge Winthrop already pointed out, this case was tried to the court with no requests made for findings or conclusions. Therefore, all reasonable inferences must be taken to support the prevailing party. If there's any substantial evidence to support the judgment, it should be affirmed. What this court should not be doing is reweighing the evidence. Recognizing this highly deferential standard, the Mark Otto parties argue that the Superior Court erred by admitting and considering parole evidence. However, the Mark Otto parties never objected to any evidence as improper parole evidence. Not in the pretrial statement, not during trial, not in any post-trial briefs. We didn't see this parole evidence argument until we got to the Court of Appeals.
So is your position that issue is waived?
Yeah, I think it's like any other argument you want to make. If you don't make it below, you can't make it up here. Yes.
Counsel, when did this notion that an estimate denotes a precise sum? I've been sitting here trying to figure out how to put it in as clear terms as I can. When did this enter the discussion or into the documents or into the understanding? Estimate, I think, in common terminology, in common dictionary usage, is not a precise sum, and yet it has become a precise sum here, as I understand it.
Well, Your Honor, I think, Judge Jones, I think you've sort of hit the nail on the head.
When did that happen?
After the deal was signed and after Mark realized that the taxes he would owe or might owe might exceed the estimate showing on Schedule F. His first lawyer, Scott Weiss, and these letters are in the record, when this first arose, and this is some time after the deal closed, began writing letters saying, you owe us any money that exceeds the tax estimates in Schedule F. And we said, no, that was the deal you were trying to get when you bargained for Romanet 4. And that isn't there. We didn't agree to that. We agreed to give you estimates. We gave you estimates, but that's precisely what they are. They are estimates. It was not, there was no time during the course of the negotiation of the transaction. And again, we cite to the court some emails where the Mark Otto parties agree to delete Romanet 4, which was the guarantee that Allen would be on the hook for anything above a certain number that his brother paid. And Mr. Weiss, again, in emails, that part of the deal kind of came in and out, Your Honor, and I think that's pretty clear from the record.
Which part?
The Mark Otto party's demand that if his taxes exceeded a specific number, the amount shown in the estimate, that Alan would be on the hook for the difference. And we cited the whole email stream below, and also had Mr. Aaron testify that came in and out of the deal, and that ultimately Alan refused to guarantee the sum. What he had provided was estimates. And if the court, and I'm sure the court had, I shouldn't say it that way, when the court reviews Schedule F, earlier Mr. Kirksmer, when he was talking about that date, June 2012, says it only applies to one column. That's simply not true. If you look at the top of Schedule F, you'll see that it's as of that date. Back to your point, it wasn't until after the deal was over. Excuse me. So in these negotiations back and forth regarding Romanet 4, Mr. Weiss finally agrees in some emails that are in evidence that Mark will rely on Section 5.02 and 5.03 regarding his tax position. One has to do with tax allocations, one has to do with tax positions, but when you go through that evidence, there's no indication at all that they, despite the deletion of Romanet 4, they continue to rely on the estimates in Schedule F. We had 4 days of trial. We had 8 witnesses. We had 260 plus exhibits.
Mr. Gordon, just curious, how does your client's then payment of $200,000 to the Mark Otto side square with your position that there was not a de facto agreement to indemnify?
Yes, Your Honor. They cite one email by a fellow at Otto who was the CFO. That letter, as we explained in our brief, and as he explains in his deposition testimony, which was also before the court, he never read the final agreement. He didn't know what was in the final agreement. He just thought it was in the agreement. But it is not an admission that created a term that wasn't in the contract.
Did the $200,000 payment pay off the estimated sums?
No, it did not. Did
it correlate?
No, it did not. It was simply and this is all in the record, Your Honor.
I'm making a record right now.
The $200,000 sum was simply the amount that Mark was demanding at that time. As we explained in our brief, and as we explained at trial, the witnesses explained at trial, at that point in time, it was necessary to get Mark Otto to sign some loan documents going forward, or the banks were still going to close the company down. And as the testimony below shows, we used the word extortion. We simply had no choice. We had to get that. So we said, here's your $200,000. But to Judge Winthrop's question, there were multiple witnesses talking about that, and Judge Goss was entitled to put whatever weight he chose or not to choose on that particular letter, and that's the only thing of the sort. I mean, they cite at length certain selected emails from Mr. Schul trying to create a concession that there was a guarantee on the tax amounts. And Mr. Scholl testified at trial. He said, yes, there was an indemnification provision under certain circumstances, but let's not get into a fight about that until we figure out what's going on and whether there is in fact any indemnification obligation. We've never argued there's no indemnification obligation. And clearly Judge Goss, having seen Mr. Scholl and read the emails, accepted Mr. Scholl's explanation of what he meant when he wrote those. That's exactly why the Superior Court is in the position it's in and why this court has such a deferential standard. I want to address one comment Mr. Kirchmer made so I don't forget it. He said that the appellees conceded that there were indemnification provisions in the contract. That's true. And that if we breached those agreements, we owed the excess taxes. Those are his words. That's simply not true. The indemnification agreement entitles them, assuming there was even a breach of an underlying clause that would trigger the indemnification, whatever particular damage flowed from any particular breach. Why this is important is no matter how they try to describe what they've done, they always come back to the point there was some number in Schedule F that didn't match what the ultimate numbers were. That is in fact a breach, and that is in fact you owe us, regardless of what that number was, big, low, small, whatever, you owe us everything we owe in taxes above the estimate. And that's why we kept saying, no, you tried to get that, you didn't get it, and you're not entitled to it now. As I said earlier, Mr. Kirchmer also said that the June 12th, remember, Schedule F says estimates as of June 30th, 2012. And then he said it only applies to one column on that. That's simply not true. If you look at the top of that's Exhibit 231, it's right under the heading. Those were all estimates. The trial court asked Mark's expert if she thought, if she thought or seen anything she thought was done untoward vis-a-vis the estimates, and she testified that it's not. The word, as Judge Winthrop noted early in Mr. Kirchmer's argument, there was a lot of difference of opinion as to what the various parties were entitled to or not entitled to under the contract. That's why we had a long trial with all those exhibits. Both Mr. Raftery and Mr. Aaron said everyone knew these were estimates. It says they're estimates. There was not a guarantee. No one would guarantee. They're saying they are a guarantee. They talk about the allocation of the purchase price. And as the court knows, there was an aggregate amount paid for all the companies, and then that purchase price has to be allocated among the companies for tax purposes. And the contract and Schedule F, which is clearly part of the contract, they're relying on it, said that these are preliminary numbers only, that they will be allocated subsequently. They're now arguing, the Mark Otto parties are now arguing, that no, you can't alter what the witnesses testified, or some of the witnesses testified were estimates. Again, Judge Goss, trying the case, seeing the evidence, is in the best position to make that determination. And the same is true of the other provisions as they go down. We've got the record sites. I mean, I know I've been at this a long time. I'm sure everyone says what I'm about to say. Their representation of what was in the record is not what we believe are accurate. The court will review those records. And again, it's the totality of all that evidence that Judge Goss was reading. Remember, under Taylor and its progeny, Arizona uses what they call in that case the Corbin view, where the trial court, where there's no jury, considers what it thinks it needs to consider to figure out what the parties intended. Unless the court has any further questions.
Thank you.
Very brief, because I have to be. To answer your question, Judge Jones, the $200,000 absolutely corresponded to the amount that Mark then had in excess taxes. If you look at the exhibit, and I apologize, Exhibit 94, the letter, it says the enclosed check to Mark for $200,000 is for reimbursement of 2012 taxes paid by Mark. The K-1s issued to Mark will be amended and should be available next week. Upon Mark filing a timely, amended 2012 tax return, the actual tax due from ordinary and capital gain income shall be adjusted. If there is additional tax owed by Mark, the company will pay the additional amount to Mark as outlined in the equity interest purchase agreement. That's a year after it closed.
Did you say estimated or excess?
Excess, Judge Jones. Estimated does not appear.
So that $200,000 was intended to cover excess taxes in their totality.
That exists.
Beyond the stated sum that was in the agreement.
That existed as of that moment, and a commitment to pay the additional once they amended their taxes once again.
Thank you, counsel.
Thank you.
We appreciate the briefing and argument presented here today. We're going to take this matter under advisement. We'll issue a written decision in due course. And with that, we are adjourned. Thank you.